Hello everyone. So today we'll be starting with the monthly magazine of Vision and we'll be starting with the July section. The target is to complete the July monthly magazine before August ends. So we'll be starting with the Polity section. We'll be doing Uniform Civil Code, Judicial Pendency, Directorate of Enforcement. Then we have Multi-State Cooperative Societies Amendment Bill, then Cinematograph Amendment Bill, then we'll do the news and shorts. Let's begin. We are starting from today. Today is 26th August 2023. You're free to join me, or you can just watch this as a revision or your starting point. So let's start. Uniform Civil Code. Recently, the 22nd Law Commission of India The 22nd Law Commission of India sought suggestions from various stakeholders on Uniform Civil Code. As we all know, um, our parliamentarians have been pushing UCC in recent times, and there are many other regional leaders who are opposing it. So let's see the background of UCC. Pre-independence period, Lex Loci Report, 1840, emphasized the importance of uniformity in codifying the Indian law related to offences, evidences, and contracts, but recommended that personal laws of Muslims and Hindus should not be codified. Then we have B.N. Rao Committee 1941 recommended a codified Hindu law which would give equal rights to women. So, pre-independence period, we have two reports. We have a Lex Loci report 1840, and we have B.N. Rao Committee report. B.N. Rao Committee report 1941. Then post-independence, we have the Special Marriage Act 1954. It has the provisions for civil marriage for people of India and all Indian nationals in foreign countries, irrespective of religion or faith, followed by either party. This nationals in foreign countries, this is also given. You must be aware that in South Africa, Indians could not marry legally because it was not allowed over there to marry outside your. It was a complicated system in South Africa. So this clause must have been added due to that. Then we have four major enactments on Hindu law, was Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Minority and Guardianship Act 1956, and Hindu Adoption and Maintenance Act 1956. About UCC, UCC provides for the formulation of one law for the entire country which would apply to all religious communities in their personal matters such as marriage, divorce, inheritance, adoption, and succession. Currently, Indian personal law is complex, with each religion adhering to its specific laws. For instance, Hindu Succession Act 1956 governs Hindus, Sikhs, Jains, and Buddhists. Muslim personal law governs Muslims, and Indian Succession Act 1925 applies to Christians, Parsis, and Jews. Earlier, the Law Commission had furnished a consultation paper on reform of family law in 2018, which stated that a UCC was neither necessary nor desirable at this stage. It recommended that existing family laws across religions required to be amended and codified to tackle discrimination, inequality in personal laws, and limit ambiguity in interpretation and application. So we know that Goa is the only place in India where a form of UCC is in practice due to the Portuguese Civil Code of 1867. It's a pre-independence era law. Okay. So we have arguments in favor of UCC, constitutional mandate, Article 44. Then it promotes secularism, and then national unity and integration. Yes, promoting common citizenship. Then we have gender justice, by eliminating discriminatory practices. UNHRC has called on India to implement a UCC that would help India demonstrate its commitment to the principles of equality and non-discrimination. So this is a huge point in favor of UCC. And simplification of laws, yes, and adapting to modern times. Arguments against UCC, against diversity, yes, because it would violate religious freedom, Article 25 of the Constitution. It may dilute the unique rights and protections enjoyed by minority groups and erode their cultural autonomy. And lack of consensus, because we have seen there are many opinions regarding it. People don't want to lose on to their religious laws, and without consent would lead to social unrest. Federal structure, like UCC could encroach upon states' legislative competence, thereby infringing on principles of cooperative federalism. Okay. Argued that states are better positioned to assess and legislate personal laws to suit their people's needs, given their proximity to grassroots realities. Now we will see important judicial pronouncements related to UCC. We have Ahmad Khan versus Shah Bano Begum case. In others, 1985, Parliament should outline the contours of UCC. Then, Sharla Mudgal versus Union of India, 1995, reiterated the need for Parliament to implement UCC. In Shaira Bano versus Union of India, 2017, SC held that practice of talaq-e-biddat or instantaneous triple talaq is unconstitutional. Okay, way forward, we need consensus, we need strong political will, awareness must be there, eradicating discrimination, adopting a piecemeal approach, that UCC should ideally be reached in a piecemeal manner, like the recent amendment on the age of marriage. This could also pave the way for internal reform and change within religious dispensation. Certain Indian laws already follow a uniform code in most civil matters: Indian Contract Act, Civil Procedure Code, Partnership Act, Evidence Acts, etc. Codification of all personal laws. By codifying laws, one can establish universal principles that promote fairness instead of enforcing a rigid uniform code, which may deter people from resorting to legal recourse, as marriage and divorce matters can be resolved through extrajudicial means. So we understood what UCC is, and these are important ones. Shah Bano Begum case 1985 and Shaira Bano case 2017. So Shah Bano case was about UCC and Shaira Bano was about triple talaq. Then we have reports: Lex Loci report 1840, B.N. Rao committee report 1941, post independence we have Special Marriage Act and four major enactments of Hindu law. Now, judicial pendency. Ministry of Law and Justice recently informed the Rajya Sabha that over 5.02 crore cases were pending in various courts. 5.02 crore cases are pending. It's a huge number. So what does judicial pendency means? It refers to clogged state of judicial system in India, where the quantum of litigations is spiking exponentially, but the output in form of judgments or settling of disputes moves at a slow pace. Data bank: 69.76 thousand, 60.6 lakh and 4.4 crore causes are pending in Supreme Court, High Courts and District Subordinate Courts. Okay. 21 judges for every million people, whereas Law Commission had recommended 50 judges per million. This is important. 0.08 to 0.09% of the GDP is the budgetary allocation to the judiciary. The reasons for pendency is low ratio of judges to population, infrequent adjournments, is not followed in over 50% of the matters, and lack of infrastructure, adequate funds नहीं है, internet नहीं है, lax idle working style है, and delayed investigation, non-availability of counsel, misaligned incentives, complexity of facts involved. Other issues may abusing contempt of court power, improper courtroom behavior, etc. Way forward, appoint more judges. An all India judicial services examination can be considered to maintain high standards in judiciary. Article 20, 224A and 128 can be invoked to appoint ad hoc judges. So, a way forward is appointing ad hoc judges. Promoting alternate dispute resolution such as Lok Adalat, arbitration, mediation, conciliation, etc. for civil cases can help to reduce the burden on courts and facilitate robust legal practice. Strengthen infrastructure. Government should provide adequate funds for developing and upgrading the judicial infrastructure, training judicial staff, etc. Setting a time limit. A time limit should be set for hearing a case and deciding. We can set up fast track courts, fix limiting time limits or deadlines for certain categories of cases. Then changes in criminal justice and procedure laws. Reduce the criminalization of violation, this is very important, and move towards the compounding of minor offences. Reform forensics and ballistics testings by outsourcing of accredited laboratories. Grievance redressal. Government departments must establish a strong internal grievance redressal mechanism and empower designated officers to decide disputes between employers and departments. Create a law-abiding society. Introduce incentive and sanction-based models of motivation to ensure that citizens abide by the law. Prohibitive penalties should be imposed to check traffic violations, civic violations, including littering in public, first-time petty offenders, etc. So, incentive to curb judicial pendency, Memorandum of Procedure 2016, transparency in judicial appointments, and setting up a permanent secretariat in Supreme Court. Then Project Sahyog to reduce pending cases. We have a Project Sahyog, Legal Information Management and Briefing System LIMS. The first application for monitoring cases involving the central government of India and transmission. We have Mediation Bill 2023 provides pre-litigation mediation by parties. We have e-courts, National Litigation Policy (NLP). NLP is National Litigation Policy. Then we have administrative mechanism for resolution of disputes, AMRID, to resolve interministerial departmental disputes in fast track courts. Now the third topic is Directorate of Enforcement, ED. Okay, why news? Recently, Supreme Court declared that the third extension given to the Directorate of Enforcement Chief is invalid. Oh wow. Okay. So what we need to remember about ED is this part. Enforcement of acts by ED. We have PAMLA, Prevention of Money Laundering Act 2002. We have FEMA, Foreign Exchange Management Act 1999. Then we have FEOA, Fugitive Economic Offenders Act 2018. And then we have Sponsoring Agency under the Conservation of Foreign Exchange and Prevention of Smuggling Activities, COEF, COFI POSA, 1970. Supreme Court upheld the amendment to the Central Vigilance Commission Amendment Act 2021, Delhi Special Police Establishment Amendment Act 2021, and the Fundamental Amendment Rules 2021 allow the tenures of directorates and Central Bureau of Investigation (VD) a maximum of 3 annual extensions. Maximum of 3 annual extensions. However, Supreme Court ruled that the current ED chief's term extension was unlawful for violating the mandate of the Supreme Court 2011 judgment. What had barred the further extensions? So, ED is a multidisciplinary organization mandated to investigate economic crimes and violations of foreign exchange laws. Okay, so ED is for economic crimes and foreign exchange laws. Works in the Department of Revenue, Ministry of Finance. ED, Department of Revenue, Ministry of Finance. You have to remember this, extremely important. Headquarters is in New Delhi. ED is appointed as per the provisions of CSE Act 2003, Central Vigilance Committee Act. Tenure should not be less than 2 years, and any transfers has to be sanctioned by the appointing committee chaired by CVC. The mandatory 2-year appointment period is followed by a maximum of 3 annual extensions under the Central Vigilance Commission Act of 2021. Power to seize assets, say search and seizure, then power to summon, so ED has the same power as a civil court regarding discovery, inspection, production of evidence, summons, examining, issuing commission, etc. Power to arrest, in the corrects of violations of PAMLA, FEMA without waiting for registration of a formal FIR. Record admissibility, recorded by ED officials can be admitted as evidence in court. As they are not police officials and thus not subject to challenge on the grounds of being self-incriminatory. Okay, this is important. Recovery of fines, penalties, and arrears of penalties. Issues abysmal conviction rate. Conviction rate is as low as 0.5%. Lack of transparency, lack of clarity and transparency about ED selection of cases to investigate. Okay. Used as a political tool by ruling party. Falling credibility has been tarnished by allegations of corruption, lack of impartiality, and a close nexus with the political class, lack of workforce. ED needs more resources, infrastructure, and workforce to deal with the rising complexities and economic offenses. Way forward, enhancing capacity. It needs proper training in modern technology to surge in the high value money laundering, cyber crimes, and cryptocurrency related cases. Regulations should be guided by the rule of law and must be transparent, non arbitrary, and based on facts rather than being politically motivated. Reducing pendency, they need fast track courts and special benches, oversight committee to overlook and streamline the case selection process. Awareness and protection, public awareness should be generated about ED's role, reform its image, and encourage whistleblowers to come forward. So, ED, we have to remember two things. First, it comes under Department of Revenue, Ministry of Finance. Second, it has 4 laws under it. We have PAMLA, um, that is Prevention of Money Laundering Act. We have FEMA, Foreign Exchange Management Act. Then we have PAMLA, FEMA, FIOA, Fugitive Economic Offences Act, Fugitive Economic Offences Act, and the fourth one is COFE person. COFE person. That is Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. Conservation of Foreign Exchange and Preventing of Conservation of Foreign Exchange and Preventing of Smuggling Act. Smuggling Activities Act. Then Multi-State Cooperative Societies Amendment Bill. In Supreme Court, the Union of India versus Rajendra Shah and others stated that Part 9B of the Constitution of India applies only to multi-state cooperative societies. And the both houses have passed it. What's the act? Application, okay. What will come to one state? Central Registrar. Every multi-state cooperative society may make its bylaws consistent with the provisions of this act. Okay. Prior approval of RBI in accordance with Banking Regulations Act 1949. Other developments, Cabinet has approved 3 national level MSCs. MSCs representing namely National Multi-State Cooperative Export Society, National Multi-State Cooperative Organic Society, and Seed Society. So we have export, organic, and state, multi-state cooperative societies. Cooperative principles, voluntary and open membership, member economic participation, education, training and information, democratic member control, autonomy and independence, concern for community. A need consistency with Part 9B, fulfillment of cooperative principles, need for reform in MSCS, revival of sick MSCS through dedicated fund, accumulated loss equals to exceeding the total of its paid-up capital through reserves and surpluses, and separate cash losses in the past of mentions. Key features of the bill: establishment of a cooperative election authority, amalgamation and division of cooperative societies, fund for sick cooperative societies, restriction on redemption of government shareholding. The bill amends this to provide that any shares held by central and state governments cannot be redeemed without the shareholders' approval. Redressal of complaints. No cooperative ombudsman. Against the directions of ombudsman may be filed with the central registrar. Composition of board of directors. The board of multi-state cooperative society will have a maximum of 21 directors. May opt to additional directors, and they have to include 1 scheduled caste or scheduled tribe and 2 women members. So 1 SC or ST and 2 women. Then the first one is for Cinematograph Amendment Bill 2023. Yes, this July actually came way back. I think 15 days have already passed away. So you can go and check it. Okay, so moving on, we are doing Cinematograph Amendment Bill 2023. So, why in the news recently, both the houses passed the Cinematography Amendment Bill 2023. The bill amends the Cinematograph Act 1952, enacted to make provisions for certifying cinematograph films for exhibition and regulating exhibitions using cinematographs. Okay. The Act provides for establishing the Central Board of Film Certification (CBFC) for certifying films for exhibition. Such certifications may be subject to modifications or deletions. Board may also refuse the exhibition of films. So, what is CBFC? Its headquarters is in Mumbai, obviously. It's a statutory body under Ministry of IB, Information and Broadcasting. It regulates public exhibition of films under provisions of Cinematograph Act 1952 to ensure the good and healthy entertainment in accordance with provisions of Cinematograph Act 1952 and Cinematograph Certification Rules 1983. Its mission is to make certification process transparent and responsible, develop CVFC as a center of excellence, adopt modern technology for certification process, etc. Consists of non-official members and a chairman, all of whom are appointed by central government. 9 regional offices are there at Mumbai, Kolkata, Chennai, Bangalore, Thiruvananthapuram, Hyderabad, New Delhi, Cuttack, Guwahati, and these are assisted in the examination of films by advisor. So, what's the bill? The proposed amendment aims to make the certification process more effective and in tune with the present by introducing new certification categories. So we'll just look at all the certification categories one by one. Age-based certification. So bill introduces three age-based certifications under UA category. UA is basically underage. That means UA is basically without restriction but subject to guidance of parents or guardians. So we have UA 7 plus, UA 13 plus, and UA 16 plus. UA 7 plus, UA 13 plus, and UA 16 plus. We already have U, meaning universal without restriction. UA, that means underage. It needs some parental guidance. A is for adult only, and S is only for members of any profession or class of people. These are meant for parents or guardians to consider whether their children should view such film or not, and they are only recommendatory. A separate certificate for television and other media. Films like A or S certificate will require a separate certificate for exhibition on television or any other media prescribed by the central government. Certificates to be perpetually valid. Certificates will be perpetually valid as opposed to the present validity of 10 years. Okay. Provisional powers of central government. Bill omits Section 6(1) of the Act as directed by Supreme Court in Union of India versus KM Shankarappa case 2000, which states that Centre cannot exercise revisional powers on films already certified by the CBFC. Make film piracy punishable offence. The bill prohibits the unauthorized recording, that is piracy, and unauthorized exhibition of films and makes it punishable offence under provisions of Copyright Act 1957. penalty would be in case of violation. So bill tends to address the existing problems faced by film industry and regulates the content by new certification categories. Meanwhile, the current viewership is starting to tilt towards the OTT platforms like our Hotstar and the Geo Cinema. An early regulation of them is necessary for the betterment of society and industry. Now, news in shorts. First is the right to silence. Supreme Court said that all accused have a right to silence. Investigators cannot force them to speak up or admit guilt. Right to silence emanates from Article 223, which states that no one can be compelled to be a witness against himself. That is, no one can incriminate against himself, but limited only to criminal proceedings. Right is not available to a person being integrated under Customs Act 1962, Foreign Exchange Management Act 1999, since the person is not accused or of an offence and isn't entitled to a lawyer. Okay. In Nandini Satpathy versus P.L. Dani case, she stated that compelling a person to answer a question within the limits of police station may result in violation of Article 23. What does it say? No, no one. Oh, let's continue. Article 23 is no one can be made a witness against himself. Okay. The second is SOP to check the use of freebies, liquor to lure voters. SOP is statement of purpose. Central Board of Indirect Taxes and Customs (CBIC) issues SOP to limit the usage of freebies, liquor, or attract voters. It aims to prevent suspicious cash, illicit liquor, drugs, narcotics, freebies, and smuggled goods during assembly and general elections. Earlier, Election Commission had also expressed concerns that smuggled goods, contraband, and other illicit articles may be used to lure voters. What are the key highlights of SOP? GST and custom officials to monitor the distribution of coupon-based or free fuel or cash for alluring prospective voters. Setting up of flying squads and static surveillance teams for vehicles check and verification of warehouses. Movement of items like saris, party flags, etc., associated with candidates or political parties without an e-way bill may be confiscated. CBIC is Central Board of Indirect Taxes and Customs. Headquarters is in New Delhi. It is an administrative authority for Central Excise, Central GST Commissionerates, Custom Houses, and Central Revenues Control Laboratory. Ministry is Ministry of Finance, Department of Revenue. We must remember ED was also in the same department. and headed by a chairman, deals with the formulation of policy concerning levy and collection of customs and central excise duty, prevention of smuggling and matters relating to customs, central excise and narcotics. Then we have demarcation of roles of MCA and METI. So, Centre has demarcated the role of both ministries to remove the possibility of duplicity of regulations on digital markets. India's digital market is expected to touch $1 trillion by 2025-26. This is a great one. So, India's digital market in 2025-26, $1 trillion. Ministry of Corporate Affairs would be nodal ministry to look into all the competition issues in the digital market. MeitY, Ministry of Information Technology, will look into sector-specific issues. The government is working towards introducing legislation including Digital India Act, Digital Competition Law for regulating various facets of digital market in India. Then we have dark patterns. Okay, Advertising Standards of Council of India. Advertising Standards of Council of India has issued guidelines for dark patterns implemented from 1st September 2023. A dark pattern is a user interface crafted to trick or manipulate users into making choices detrimental to their interest, like buying a more expensive product, paying more than what they initially disclosed. Misleading advertisements are defined under the Consumer Protection Act 2019. Addresses four online advertisement techniques. This is very important. Drip pricing. Elements of the cost are not revealed upfront. Guidelines of this price shall include all non-optional taxes, duties, fees, etc. Then false urgency phenomena when companies state implied quantities of product or services are more limited than they actually are. Then distinguished ads. Advertisements resembling editorial or organic content must disclose that it is an advertisement like paid reviews, influencer posts, etc. Bait and switch. Advertising one product or service but delivering another, often of lower quality. Okay. So we have four: drip pricing, false urgency, distinguished ads, and bail and switch. Established in 1985, ASCI, Advertising Standards Council of India, in 1985, from the advertising and media industry to keep Indian acts decent, fair and honest. This is a voluntary self-regulatory organization comprising members from India's marketing, creative media and allied companies. ASCI has been committed to protecting Indian consumers' interests through self-regulating in advertising. Okay, so Polity is complete. We'll do tomorrow international relations and move on. Thank you so much for being with me till the end. You can go and download the July Current Affairs magazine from Vision's free resources, and you can either follow with us or you can do it on your own. But our target will be to complete it by the end of August. Thank you and have a nice evening. Please continue studying as we all are going to do. Thank you so much.